Rip the torn carpet and gaping holes in the walls, doors hanging off the hinges. When a tenant moves out, some damages goes above and beyond the usual. But as most seasoned landlords know, these things are rarely straightforward. What do you do about scuff marks on the hardwood flooring or nail holes from hanging pictures? What about dirty appliances? Can you charge a tenant to bring the property back into the same condition it was before they moved in? Of course, tenants want their security deposit back in full. But as a landlord or property management company, you must retain the deposit to apply toward any damage that the tenant is responsible for. When it comes to assessing what issues were caused by normal use and which problems are more excessive, it can get complicated. When the tenant moves out, it's up to the landlord or property management company to process their security deposit and return it in a timely manner. This deadline varies considerably from state to state, but here in Texas, it is 30 days. To further compound the issue, state and local regulations vary considerably on how security deposits should be handled. Not surprisingly, disputes regarding security deposits are among the most common reasons landlords and tenants end up facing each other in court. Hi, my name is Pete Candelario, and I am the broker and one of the owners of RE Solutions XV, a residential real estate and property management company that loves to educate and help people find solutions for all of their real estate needs. And if you want to see more videos like this, hit the subscribe button and bell to get notifications whenever we upload a video. So normal wear and tear can be confusing. Some owners want to charge tenants for every little thing upon move out, but that's what gets landlords in trouble. As a property management company, we strive to keep our property owners out of court by itemizing the security deposit honestly and fairly for both the property owner and the tenant. We use documentation and pictures taken from before, during, and after the tenancy to evaluate if a charge goes against a tenant or an owner. If we do not have proper documentation, then the charge will normally default to the property owner. And that's because it is normally the cheaper route. If a tenant takes a landlord to court for what they believe that the landlord kept part or all of their security deposit in bad faith, they can be awarded 3 times the amount taken if the judge rules in their favor. For this reason, we at RE Solutions conduct the itemization of security deposit on behalf of the property owner, as property owners are not aware of what is considered normal wear and tear. To clear up some of the confusion surrounding this issue, here are some guidelines for the typical areas where damage occurs in a rental to help determine whether it falls under the category of normal wear and tear or is something more serious. Flooring. In most cases, you can't expect the floor to be in pristine condition after a tenant leaves. Carpet naturally has a limited lifetime, especially if it's a lighter color. High traffic areas will naturally become worn down, and it's common to see a few light stains and indentations from furniture. A steam clean customarily performed between tenants should bring the carpet back into decent shape. However, pet stains, holes, and burns generally go beyond everyday wear and tear. When it comes to hardwood flooring, the same standards apply. Worn scuff flooring in areas that receive a lot of traffic is to be expected, while deep gouges or an extensive series of scratches are usually indicative of tenant damage. With tile or linoleum, it largely depends on the quality of the flooring and what has caused the damage. If linoleum is starting to peel near the door, for example, it's most likely the result of normal use. Broken or chipped tiles or deep scratches in flooring could have been caused by dropping heavy items or dragging something across the floor, and may be damage that the tenant could be held responsible for. Walls and doors. Faded paint or scuff marks are considered normal wear and tear, and minor superficial damage such as a few small nail holes or a hole where a door handle hit the wall is usually considered normal wear and tear as well. These small issues can easily be repaired and shouldn't come out of the tenant's security deposit. However, pen marks all over the walls or deep gouges or dents that will require more than some quick spackle to repair are usually considered excessive. Similarly, the cost to repair or possibly replace doors that are hanging off the hinges or sliding doors that have come off their tracks and have been banged around can usually be deducted from the tenant's security deposit. Appliances. Appliances that you supplied with the unit, such as air conditioners, furnaces, stoves, refrigerators, and washers and dryers, all age and will break down eventually. Your job is to determine whether the unit in question wore out on its own or was damaged by the tenant intentionally or by improper use. For instance, if your new appliances are broken and are still under warranty, you may want to find out the cause. For machines that are older than 5 years old, though, the breakdown could be normal wear and tear. In most cases, You shouldn't take the cost of replacing appliances out of the tenant's security deposit unless you can prove that they caused the damage themselves. Pet damage. One of the age-old landlording questions is deciding whether or not to make your rental pet friendly. But just because you allow pets in your property doesn't mean that you have to allow pet damage. Stained carpets, holes in the yard, and scratch or chewed floors, walls, or doors are not generally considered normal wear and tear and can all come out of the tenant's security deposit. Dirt and grime. While you can't require your tenants to shine the floors on their way out, this doesn't mean that they have the right to leave your property in a filthy state either. Clogged drains from misuse or neglect, filthy bathtubs, showers, sinks, or toilets, food in the refrigerator or cabinets, a grimy stove, and piles of trash can all be considered excessive, and such in cases it's not unreasonable for you to charge a cleaning fee. Just make sure to be clear about your expectations for the condition of the rental before your tenants move out, so they know exactly how you expect them to return the property to you. The best test for these cases is whether the property has been returned to you in a way that is considered to be reasonable, taking into account the amount of time that the tenant occupied. For example, if you recently had new carpet installed and the tenant was only in the property for 6 months, then the cost of replacing damaged carpet should come out of the security deposit. If, however, the carpet is 10 years old, then you simply can't expect the tenant to pay for a carpet upgrade simply because it's worn out. Finally, when it comes to security deposits, one of the best ways to protect yourself is being proactive. Make sure you specify in the lease the condition in which you expect the rental to be returned to you. This should help to clear up any confusion and keep everyone on the same page. Another important tip is to always document everything. At RE Solutions, we conduct several inspections of the property before, during, and after the tenancy. We document everything with photos and a PDF report that's kept on file, which is the best way to demonstrate the condition of the property and will prove to be invaluable when it comes to withholding a security deposit or having to prove your case in court. Check out our video on property inspections. Security deposit itemization is probably the most litigious portion of being a landlord. That is why it is always a good idea to have an experienced property management company by your side. If you have any questions on this video or any other real estate or property management question, do not hesitate to contact us. Our contact info is in the description below. Till next time, take care.